Good afternoon, everyone. This afternoon, I am joined by Professor Steve Schwinn, Professor of Law at the University of Illinois Chicago Law School. Steve, thank you for joining us.
Thanks for having me, Kathy.
Professor Schwinn and I plan on taking a moment throughout the term to explore some of the cases that are before the justices, look at the decisions that are coming out, and maybe discuss some breaking news as it happens. This is the first in a series of videos we hope to present to you throughout the term, and we're excited to get started. So Steve, to start us off for this term, on the very first day of the term, the justices are going to hear a somewhat funky, odd little First Amendment judicial independence case called Kearney V Adams. And this case sort of sits at the intersection of a lot of really buzzworthy political terms: judicial independence, political parties, election, First Amendment. But I think it's a case that really isn't getting very much coverage. And you did a wonderful article for us in our ABA Supreme Court preview publication and really dug into the issue. So I was wondering if you could talk a little bit about what the justices are going to be hearing, and maybe talk a little bit about why it's not actually getting the coverage that you might otherwise expect it to hear.
Yeah, for sure. So Kathy, I think the way you set this up is perfect. It really is a funky case, funky and complicated. And so let's see if we can kind of walk through it in a way that makes sense. There's an attorney in Delaware, James Adams. And James Adams has, over the course of his career, kind of said, on and off, that he'd like to throw his hat in for a judicial position in Delaware. Finally, he retires and he decides that he's going to put his name up for a judicial position in Delaware. And he changes his party affiliation at that point from Democrat to independent. Now, that's significant because of the way the courts are set up in Delaware. At that point, he claims that he cannot qualify for a judicial position that he wants in Delaware. And so rather than applying and getting rejected, he goes ahead and sues and argues that the way the courts in Delaware are structured prevents him as an independent from getting a nomination and a seat on the courts that he wants in Delaware. What he claims in particular is that the way the courts are set up violates his First Amendment rights to associational freedom, political associational freedom. And so this is a really big deal in that sense. Now, the way the courts are set up, this is where things get a little complicated. So in Delaware, what they've tried to do is create a kind of bipartisan judiciary in order to inspire confidence in the judiciary and keep it as kind of nonpartisan, or at least politically balanced as possible. And so there are two key features in the Delaware Constitution that move to do this. The first one is called the bare majority rule. What the bare majority rule says is that on Delaware courts, a bare majority of the judges or justices must be of a major political party, Democrat or Republican, the bare majority rule. Means just what it says. The second provision in the Delaware Constitution is the major party rule. Now, the major party rule works in some ways hand in hand with the bare majority rule. What the major party rule says is on certain courts in Delaware that are subject to the major party rule, the other judges or justices on that court have to be from the other major political party. So for an example, take the Delaware Supreme Court. 5 justices on the Delaware Supreme Court. What the Constitution says is that 3 have to be of one major political party. Let's just say Republican, just for the sake of ease. So 3 are Republican. But the major party rule says that the other 2 have to be the other major political party, or Democrat. So there are 2 Democrats, 3 Republicans, 2 Democrats. That doesn't leave any room for an independent like the plaintiff in the case. Now that applies, those 2 rules apply together to the state's major courts, the Supreme Court, the Superior Court, and the Chancery Court, the so-called business courts in Delaware. But there are other courts in Delaware as well, in particular the Family Court and the Court of Common Pleas. Those courts, the Family Court and the Court of Common Pleas, have the major party rule, but they don't have, I'm sorry, they have the bare majority rule, but they don't have the major party rule. And what that means is that a bare majority on those courts have to be from a major political party, but then the rest of the seats can be to the other party or any other party. And so our independent plaintiff could qualify for the family court or the court of common pleas. Anyway, he argues that this whole structure prevents him as an independent from getting a judicial seat in Delaware, and that it therefore interferes with his First Amendment right to political association.
Interesting, really interesting. Why do you think the justices granted cert in this case?
Yeah, so this kind of goes back to what the Supreme Court has said about all this. The Supreme Court in a line of cases has said that you can't use a person's political affiliation to fire them if they're in a non-policy making position. Okay, I'm going to say that again just for clarity. The government or a government official can't use a person's political affiliation to fire that person if they're in a non-policy making position. Now, what that means, sort of the reverse of that, is that the government or a government official can use a person's political affiliation if they are serving in a policymaking position. And we see this all the time, right? If you think about, for example, at the federal level, we see political appointees for the cabinet, but in the ordinary civil service, you can't use a person's political affiliation to hire or fire them. And that's what the Supreme Court's saying through this line of cases. Now, what Delaware has said is that we're going to pick up on that theme, and we're going to use a person's political affiliation in order to determine whether they qualify for the judicial bench, right? Now, under the Supreme Court rule, what that would mean is that judges are policy makers, and therefore the state can use their political affiliation in appointing them. So part of the dispute here is whether judges are policymakers, in which case Delaware can use their political affiliation, or whether they're not policymakers and Delaware cannot use their political affiliation. And as it turns out, the circuits are split on this. So the Third Circuit in this case said that judges are non-policy makers and that the state cannot use their political affiliation in order to appoint them. But the Sixth Circuit and the Seventh Circuit have said that judges are policymakers under this framework and that the state can use their political affiliation to appoint them. So I think part of the reason that the court granted cert was simply to resolve this circuit dispute, which is not uncommon. Circuit disputes like this, circuit conflicts like this, will often go on up to the Supreme Court.
I think that question about judges as policymakers or not is a really interesting one. And I hope educators who may be joining us today can think about ways to maybe have their students debate that, because it's a really central aspect of the legal system and of determining the rule of law. And we've heard a lot of debates about sort of the role of judges over the last however many years. But I think it's a really nuanced way to reflect on that question and how we view the role of judges in our legal system. So I hope that could be something that triggers some interest of some teachers out there, and something that would encourage people to follow along on this case.
That's an excellent point, Kathy. Can I just chime in on that? So, and what the parties are saying here is, on the one hand, judges are policymakers because they're essential in forming the state's common law, right? When judges rule on individual cases, they're of course not ruling only on the individual case, but they're also setting a precedent going forward and helping to establish the state's common law. And in that sense, they look like policymakers. On the other side, they actually are only deciding the particular case in front of them. And in that way, the argument goes that they're not really policymakers. But the policymaking debate, I'm not sure is going to get the Supreme Court's attention. And let me just say a bit why that is. So these cases, the line of cases that established the policymaker rule and the policymaker exception that I described a moment ago, those cases arose out of a concern about political patronage, right? Where a government official is hiring or firing ordinary civil servants based on their party affiliation in order to gain favor or not from them. And so these cases are really designed to avoid that problem of political patronage. With judges, we don't have the same kind of patronage problem. Once judges are appointed, they're completely independent. So the governor isn't going to demand political favors from them one way or the other, presumably, isn't going to demand the same kinds of political favors from them one way or the other after they're appointed. There's another kind of mismatch here between the political patronage cases and the Supreme Court cases and what's going on in the Delaware situation. And that is that the policymaking exception in the Supreme Court cases permits but does not require an official to use a person's political affiliation to fill a slot or to fire a person. It permits but not requires it. In contrast, the Delaware Constitution actually requires the governor to fill seats based on party affiliation. And so in some ways, you have a kind of mismatch between the Supreme Court precedent on this and what's going on in Delaware. And it's not entirely clear to me that the court will actually ask and answer that question, whether judges are policymakers for that reason. They might just not even fit into this construct.
So thinking a little bit about what the court may or may not get to, I know there's some issues of standing and severability in this case. Do you think the justices, as much as we've been spending this great discussion talking about the merits of the case, are even going to get to the merits here? Or is this going to get kicked out before we get to that part?
That's a fantastic question, and it's really insightful. So when the case went up to the Supreme Court said, yeah, sure, we'd like to hear this case. We'll grant cert, but we're going to direct the parties to answer a preliminary question, and that is whether the plaintiff in the case even has standing to sue. Now, to have standing to sue, what the Supreme Court says is you've got to show that you've been individually harmed by an action and that the redress that you're seeking in the courts will actually redress the harm that you've suffered. Now here, the factual record is a little indeterminate on this point. Here you've got an individual who, as a Democrat, remember he was a Democrat, as a Democrat would have qualified for any judicial seat. And in fact, the parties have identified a number of seats that he could have qualified during the years that he was a Democrat and said that he was interested in seeking a position on the state bench. Once he became an independent, sure, some of the positions may be foreclosed to him in the future, but here's the problem. He hasn't articulated any determinate plans to seek a slot in the future. And so it's not entirely clear that this isn't a kind of speculative harm that won't count for standing purposes. And moreover, that it's not a kind of self-inflicted harm in the sense that he switched from Democrat to independent in the first place, right? And in that switch, also sort of self-selected himself out of the pool for the business courts.
I feel like it's never a good sign when the court itself puts the standing question up for play. That's usually can tell us which way things may fold out. But if putting the standing issue aside, if you can put your sort of guessing hat on, your prediction for us, what do you see happening with this case? Is it going out on standing? If they get to the merits, which way do you think the justices may shake out on this?
I think that's a really hard thing to predict. I agree with you. It's never a good sign when the justices themselves ask the parties to brief standing. So if I had to lay a wager, I think what I'd say is that the court probably will kick this for lack of standing. If it does get to the merits, though, what's the court likely to do? I think this is really hard. I mean, here you've got a court that's fiercely protective of First Amendment freedoms of speech and association in many ways. And you've got these Supreme Court precedents that talk about the policymaker exception and the policymaker rule. You know, it's kind of hard to see where all of these ideas intersect and what the court is likely to do at the end of the day. And I really hesitate to venture a guess. I think in some ways, Kathy, I think that if the court gets to the merits, I think that it may look for a way to address the issue outside of the policymaker framework, just because that does seem to be such a mismatch here. Now, there is another issue in the case, and that is if the court gets to the merits, these two provisions that create a kind of bipartisan judiciary in Delaware, the bare majority and the major party provisions, whether they're what the court calls severable. What that means is, can the court rule on one without necessarily ruling on the other? Now, that's an interesting question, because what the court could say is that one or the other of them violates the First Amendment. And if they're non-severable, then the other one necessarily falls as well. We've already talked a little bit about how they operate kind of in tandem. And in fact, they're in the exact same constitutional language in the Delaware Constitution. And so a lot of it looks like they're non-severable. But on the other hand, the bare majority provision had existed in Delaware law for a good 50 years, 50 plus years, without the major party provision all by itself. And it continues to operate in the family court and the court of common pleas all by itself. And so there's good evidence on the other side that they are severable.
Right. What's
the court going to do with that? It's really, really hard to say.
So I'm going to use, I swear we didn't plan this, I'm going to use your severable conversation to lead us into sort of a quick overcap of if there's 2 to 3 cases that you see beyond Kearney versus Adams that might be important coming up this term, that our audience may get a sneak peek as to what we may be talking about later in the term. And I will start you off with the severability and the Affordable Care Act Obamacare case.
Yeah, what could you be talking about here, right? Severability and Obamacare. Oh my goodness. Let's just say a quick word on this case, because it is so maybe important. And I'll explain the maybe here in a second. So we'll all recall that the Supreme Court had upheld the individual mandate, the requirement that we all purchase health insurance one way or another, under not the Congress's Commerce Clause power, but instead under its taxing power. And the reasoning went like this: because there's a federal tax penalty for not getting insurance, Congress had the authority under its power to tax to issue the mandate in the first place. Now, next step, the Congress actually then set the tax penalty at $0, which meant that there was no tax penalty for not getting insurance. Okay. Now, if there's no tax penalty, what we expect is that folks won't get insurance any more than they would have before Obamacare. But it also raises the constitutional question. If the tax penalty for not behaving in a particular way is $0, in other words, if the government doesn't stand to raise any tax revenue from that non-behavior, is it still justified and authorized under Congress's taxing authority? Interesting question, right? Okay, so that's one question, but the case gets way more interesting on the severability.
Of course, it's Obamacare. It always gets more interesting.
How could it not, right? It's not that like the Supreme Court hasn't heard enough Obamacare cases that are just endlessly fascinating. So the individual mandate is a part of Obamacare, but there are other components of Obamacare as well that are essential to the way the act works in this kind of coherent, symbiotic, orchestrated way. And so there are the big three, right? The individual mandate, the community rating provision, and non-discrimination against individuals with pre-existing conditions. And all these are designed to keep healthcare both affordable and available. But then there are a ton of other provisions, like, for example, young people can stay on their adults insurance until age 26, right? And then there are even provisions that are farther afield from core healthcare, from that are tied into Obamacare. And so severability is important, because if the individual mandate is not severable, if we can't pull the individual mandate out from the rest of the act and rule it unconstitutional on its own, if it's unconstitutional and if we can't sever it, what that means is the whole act goes down, the whole stinking thing.
Mm-hmm.
And that's pretty breathtaking given everywhere where Obamacare has its tentacles. I mean, that would be a really dramatic ruling. Is it an important one, however? Well, I think that's a lot going to depend on what happens in the 2020 election. And if Democrats win the White House and are able to get a majority in the Senate or a coalition in the Senate to undo anything that the Supreme Court does, then the Supreme Court's ruling will have little effect. If instead President Trump stays in the White House or Republicans maintain their majority in the Senate, then I think we'd be looking to what the Republicans have long promised: repeal and replace. What do they have in mind? They haven't revealed that yet.
Mm-hmm.
And so maybe they do have a plan that would make this a less important case, even if the Supreme Court were to rule the individual mandate unconstitutional and unseverable. I know that was long, I'm sorry, but I think it's a really important case. And, hugely interesting given the politics, right? The ruling won't come down before the election. We know that was certain.
Which is also really interesting too, and creates a whole different political dynamic for the case.
Yeah, exactly, right? Yes, for sure. Yeah.
So Steve, in closing, no, go ahead.
I'm sorry.
I was just
going to say a couple of other things.
More.
Yeah. We're thinking the same thing, Kathy, as usual, right? So there's a really interesting free exercise case on the court's docket dealing with a rule in Philadelphia that says that that nonprofits that place foster care children into permanent homes don't discriminate by sexual orientation. In other words, they would have to place children in homes of same-sex parents as well as opposite-sex parents. And some nonprofits object to this on religious grounds and free exercise in particular. And so it'll be interesting to see what the court does with this. There's a trend line here that the court is granting more and more religious rights and liberties to religious organizations and even secular nonprofits and for-profit corporations, as we've seen. And so we expect that this case will probably follow that trend line, but we'll see where it goes. And then another huge political case, DOJ versus the House Judiciary Committee, where the House Judiciary Committee is seeking secret material from the Mueller report, all those redacted pages, those blacked out pages from your copy of the Mueller report. The House Judiciary Committee wants them, and the Supreme Court will decide whether they can get them. But, another case that won't come out before the election. And so I think both really attention getting, but also probably not in the end very important.
What I think is really interesting in all three of these cases you've mentioned is that there's a little bit of holdover from last term. We're still looking at investigations into the Trump presidency. We're still discussing religious freedom and LGBTQ rights. We're still looking at how Obamacare plays out and what Congress's role is in changing it and defining the ins and outs of it. And it's a what's old is new term, I think, certainly. But I agree with you that there are some major blockbusters lined up, and it's going to be a really, really interesting term. Even if you took it out of a presidential election cycle.
I totally agree with everything that you said, Kathy. I would only add that what's not on the docket, at least not yet, is equally important. So if we think about all the lower court cases that are percolating up with regard to defunding sanctuary cities, or with regard to the administration's immigration policies, particularly asylum policies on the southern border, or the administration's environmental policies, right? All these cases are percolating in the lower courts right now, and many of them are ripe for Supreme Court review. The Supreme Court has not granted cert in these cases, and if Biden wins the 2020 election, I imagine many of these will become moot. If President Trump wins, then we may be looking to the rest of the term and even next term for some of these future blockbuster cases.
Well, Steve, thank you for a fun and exciting conversation. I look forward to doing more of these with you throughout the term, and I would encourage any of our audience members who have specific questions for you or cases they would like us to discuss to go ahead and tweet us and let us know. And unless there's breaking news, let's plan to come back after the first oral argument session and review what's happened.
Let's do it. Thanks, Kathy.
All right, Steve. Thanks. Bye-bye.